We'll begin with Jesus Gomez Lopez.
Travis Gates on behalf of Mr. Jesus Gomez Lopez, Your Honor. He's before the court at 24 CF 2032. At this time, we're going to enter a not guilty plea in Mr. Gomez's case. He's currently scheduled for December the 9th.
Very good. The court will enter the not guilty plea and we'll come back for pretrial on December 9th, 9 a.m. In the meantime, communicate with your attorney. Okay? Thank you very much.
It's in English.
Your Honor, next should be Wilmer Hernandez.
Correct.
Travis Gates on behalf of Mr. Hernandez, Your Honor, at 24 CF 2036. We'll be entering a not guilty plea. It's already scheduled for December the 9th.
Very good. The court will accept the not guilty plea and will continue this matter until the pretrial on December 9th at 9 a.m. In the meantime, meet up with your attorney, okay? Okay. Thank you.
Thank you. And I'll let the court know I asked Madam Interpreter to stay so that we would go first instead of having to wait for seconds.
Good. Thank you. Okay. We're just going to start at the top and go through it.
Your Honor, I do have one incarcerated client who also needs the Spanish interpreter.
Okay,
If we
good.
can do that real quick,
Sure.
and then we can. No, Kina Mendoza speaks English. Korea, Vidal, Korea. Your Honor, this is Vidal Carrillo, 2024 CF 2019. If I could just, with one second, thank
Go
you.
ahead. Take your time.
Thank you so much, Your Honor. I appreciate it. Like I said, this is Vidal Carrillo. We'd like to enter a plea of not guilty today. I believe he's already on the docket for 12-9, but I think we'll have to move him to 12-11.
Very good. The court will accept the not guilty plea and we'll continue this to the next pretrial date, which is December 11th at 9 a.m.
Thank you so much.
In the meantime, your attorney will communicate with you about what's going on. Do you want to try and do out of custody first, or?
Yes, Your Honor, I can.
Okay.
All the information is alphabetized. If you just want to go down the list, it would be easier.
Okay. You want to just go from the top with incarcerated or not?
Oh, no, I have a separate for incarcerated.
So these are, so you want, so you want to go out of custody in order?
It would be easier to me, but it's.
That's fine. No, that's good. That's good. We want to do whatever's efficient.
TJ, I'm gonna call it.
So my first one is,
I'm gonna call Your Honor, Mr. Medina is not in here, Ms. Farkas is talking, so instead of, I'll go
Okay.
ahead and take mine real quick. and make it
Okay.
Easy. Your Honor, I'll start with Mark Gross.
okay,
Your Honor, this is Mr. Gross coming up before the court at 24 CF 2022. At this time, Your Honor, we'd like to enter a not guilty plea. Mr. Gross is currently scheduled for December the 9th.
very good. The court will enter the not guilty plea. Continue this to pretrial on 12/9 a.m. Meet up with your attorney in the interim and figure out where you're going with this.
Thank you, Your Honor. Next I've got is going to be Karen Tyler. Ms. Tyler is making her way up to the podium. Your Honor, Ms. Tyler's here before the court in 24 CF 2113. She does have two other cases pending with Mr. Nopes. I do believe those are scheduled for Monday.
I think so.
If we can enter a not guilty plea today, but have this case brought in on Monday, my conversation with Ms. Sharp was that if there's a resolution, she'll try to incorporate mine as well.
Very good. So we'll have a not guilty plea, and we'll come back on Monday, which is the 21st of October,
Thank you, Your Honor.
9 a.m. Thank you.
Next I've got is going to be Lawrence Jackson. Your Honor, this is Mr. Jackson making his way up. At this time, we'll enter a not guilty plea in his case. He's currently scheduled for December the 9th.
Very good. We'll accept the not guilty plea and come back on December 9th, 9 a.m. Thank you.
And then I had one other on the docket, Jamie James, Your Honor, that's out of custody. We filed a plea of not guilty in her case about 15 minutes ago. She contacted our office about transportation issues.
Okay. Which one is that?
Jamie James, 24 CF 2176.
Okay, they have her listed as an inmate.
She was released and.
Okay. Did you say you entered a not guilty?
Yes, Your Honor. She's currently scheduled for December the 9th as well.
Very good. We'll continue until December 9th, enter the not guilty plea on that case as well.
Thank you, Your Honor.
Thank you. Ms. Farkas, you want to do your out of custody first?
Sure, Your Honor. I have Austin Ford, F-O-R-D. He is present and approaching, 2024 CF 2071.
Okay.
Thank
Want
you.
to try and do these in alphabetical
Oh,
order?
I'm so sorry. I just,
That's all right.
grabbed
We'll
the
back
first
up.
one.
Well, let's do this one and then we'll
Okay,
start.
thank you.
And
I
I'll
apologize.
call them out.
okay, thank you. That's helpful. We'd like to enter a plea of not guilty today. We do have the offer from the state attorney, but just would like time to meet and discuss the case.
Very good. The court will enter a not guilty plea and we'll continue this matter till 12/9, 9 a.m. Okay? Meet
Thank
up
you,
with
Your
your
Honor.
attorney in the interim.
Okay, that's good.
So, first one I've got, Miss, that's out of custody for you, Ms. Farkas, is Antonio Clark.
Yes, he is here and present. Coming up.
You want to announce the case?
Yes, Your Honor, 2024 CF 2073. Mr. Clark would like to plead not guilty. He's already on the docket for 12/9, so we've got time to
Very
meet.
good. The court will enter
review
a
everything.
not guilty plea and we'll come back on pretrial on 12/9, December 9th at 9 a.m.
Thank you.
Next is Taylor Coleman.
Your Honor, this is Taylor Coleman, 2024 CF 2068. We have the offer from the state attorney, and I believe that my client will want to accept it. If we could just keep her on the 12-9 docket, so we've got a little more time to review it if the offer will stay open.
Court will enter a not guilty plea and come back on 12/9 at 9 a.m.
Steve.
The next case I have for Ms. Farkas is Kashane Dahani.
That client is not present at this time. I think this has the case to be on for now, just in case.
Why don't we ask the state what they're doing, and if he shows up, you can bring it to my attention rather than bring him back up. State,
I'm sorry, Your Honor, I didn't hear the name.
Dehaney, Kashane Dehaney.
Shane Dehaney. So 24 CF,
Go ahead.
20.
Okay, hold on, I know what that, we already announced the case. What,
Yes, there is court going on the first floor. I just want to make sure that he's not gone to the wrong courtroom.
if he's got it, I'll withdraw it.
Okay.
But I don't want to have to come back and keep track of everything. If they're not here, they're not here. So you're asking for a capias, state?
Judge will ask for
Court will
capias.
issue a no bond capias. Next out of custody for Ms. Farkas, I have is James Downs.
Your Honor, this is James Downs, 2024 CF 2121. Mr. Downs would like to enter a plea of not guilty. He's already on the docket for 12-9.
Very good. Court will enter a not guilty plea and continue until 12/9 on the pretrial at 9 a.m. Next case is Mercedes N. Scott, if I pronounce that right.
Ms. N. Scott is not present in the courtroom.
Your Honor, I received an email today from Mr. Rapella's office that they are representing Ms. N. Scott, and they filed a not guilty plea.
Very good. Next case I have is Corey Fuller.
Mr. Fuller is present and approaching, 2024 CF 2135. Mr. Fuller would like to enter a plea of not guilty. He's already on the docket for 12-9.
Very good. We'll continue this matter until 12/9 at 9 a.m. That's all I've got for yours. Mr. Medina, you want to do your out of
Yes, I
custody?
have one with a plea, Your Honor.
Okay. Just assume. Come here.
Your Honor, may I proceed with Travis Roy Brennan?
Sure. Hold on a second, let me. This is case number 24 CF 2038.
Yes, Your Honor, and Mr. Brennan is signing the plea agreement for a misdemeanor resolution that we've previously been over. And then the state has to sign it, and I have to sign it, Your Honor. It'll just be a moment. Thank you. May I approach, Your Honor?
I already did. That's where I just went. I'm sneaky like that.
May I approach, Your Honor?
You may.
Thank you. Your Honor, under the terms of this agreement, Mr. Travis Roy Brennan in 24 CF 2038 will be entering a plea of no contest with an adjudication of guilt to a lesser included offense, second-degree misdemeanor driving without a valid driver's license. The statutory reference is given. Credit for time served, $270 court costs, $150 public defender fees, and he'll have 6 months to pay before monetary obligations go to collections.
That's the state's offer. However, to correct the offer, it's gonna be 300 because it's a driving offense.
Oh, 300. Your Honor, could I have that back?
Sure.
Thank you. Thank you. I wasn't sure about that.
Mr. Brennan, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, I just need to ask you a couple questions about your plea. So, you heard your attorney state the terms of your plea. I see those same terms are in the written plea agreement that you've signed. Just want to make sure you've read the agreement. You've gone over it in detail with your attorney to make sure you have all your legal questions answered.
Yes, sir.
Okay. And you understand that this will be a final resolution of this case, but you are waiving the right to go to a trial. Do you understand that?
Yes, sir.
Okay, and this is in your best interest in your mind?
Yes, sir.
Okay, very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt to a lesser included offense of driving without a valid driver's license, And you've got the statutory cite. The sentence here today is technically credit for time served. And then you've got the standard court costs, $300 and $150 PD fees. You'll have 6 months to pay those before it goes to collections. Okay?
Thank you, sir.
Any questions? Thank you.
Thank you. You probably don't want that, do you?
No, I don't.
All right, good
I'm
luck.
good. Thank you.
Yes, sir.
Thank you
Take
so
care.
much. Bye-bye. You're welcome.
Hold on a second. Let me check something here, Mr. Medina.
Was it related to Mr. Brennan?
Yeah, no, not.
Oh, yeah, you're free to go.
I'm good.
Thank you.
TJ.
We've got some leftovers from the morning. We're gonna have a plea for Anthony Allen, and then Boaz and Alloway.
Is Cody Irish in the gallery? Mr. Irish, your attorney, Mr. Harper, has filed a written plea, a not guilty plea, and you're coming back, so just you don't have to stay around. You're scheduled to come back on 12/9, on December 9th. So in the meantime, meet up with, have you met with Mr. Harper yet? Okay, he's with the Office of Regional Conflict. Do we have a number for him?
I've got Mr. Kent's number, so it's the same.
Okay. They'll give you a number, call them, and make an appointment before then. You can kind of look at your different options, okay?
Thank you, sir.
Okay, thank you.
Thanks, Judge.
So we do have some folks that are on my list here as not having an attorney. So the purpose, because you all have not met with an attorney, you can see the attorneys have kind of cycled through pretty quickly because they've already talked with their clients. The purpose of today's hearing is merely to make a plea, okay? So what I'm going to do is I'm going to call you up. if you would come quickly to the podium, I'm going to ask you, first of all, whether you want to have an attorney appointed or you're going to hire private counsel. If the state wants to make an offer, sometimes they'll make an offer. You're not obliged in any way to accept that, but we'll enter a plea here today, appoint you an attorney, and if you do wish to have an attorney appointed, the court will enter a not guilty plea on your behalf. That preserves your rights, gives you an opportunity to contact your attorney, figure out what your different options are. So if you have any questions when you come forward, you can ask me, but that's just kind of a general lay of the land for those of you all who are here without an attorney. So let me just go through here quickly and okay, Susan Chang. Susan? She's what?
She's in the hall with you.
Can somebody go get her?
I know her.
Jalen Cunningham. Come on up to the podium, Mr. Cunningham. So, Mr. Cunningham, this is case number 24 CF 1622. You do have the right to have an attorney. You wish to have an attorney appointed. You're going to hire private counsel.
Can I get one appointed for?
Sure.
Sure.
The court will appoint the public defender, and like I said, I'm going to enter a not guilty plea on your behalf that preserves your rights, and we're going to come back on, continue this till December 9th at 9 a.m. In the meantime, call the Okaloosa Public Defender's Office.
Okay.
Tell them your name and meet up, get an appointment.
Okay.
I don't know which one,
This one.
who will appoint.
Okay.
I always get confused over which part of the alphabet the different
I
public
think it would be
defenders
Ms.
have.
Farkas's case C.
Okay,
All right. Thank you.
okay, thank you. Ms. Chang?
Yes, ma'am.
So, Ms. Chang, this is case number 24 CF 2127. I don't know if you heard what I just said to the other folks, but the purpose of today's hearing is merely to make a plea, but you do have the right to have an attorney. And if you cannot afford one, one will be appointed. So my first order of business is to ask you, do you wish to have an attorney appointed?
Yes, please.
Okay, so the court's going to appoint a public defender. Now, you do have to fill out the form, and if you'll fill that out and drop it off at the clerk's office before you leave, that would be helpful.
Okay,
And what I'm going to do is I'm going to enter a not guilty plea in your behalf. That preserves your rights by entering a not guilty plea, and we'll come back on December 9th at 9 a.m.
okay,
Okay, in the meantime, meet up with your attorney and look at your different options, okay?
thank you.
Thank you. Hold on. Is Pavel Harna here?
Your Honor, this is another one where Mr. Lupella filed a notice of appearance and advised that there's a written plea of not guilty. I'm not sure if it's in the clerk's site yet, but that's just the email I received.
Has there been a not guilty? And these are the two cases that you just said. Have there been an entry of a
Yes,
appearance?
that's why this time I said I'm not sure if it's in the clerk's site.
No, I'm not saying, I know you're not attesting for Mr. Lapella,
Yes.
but maybe somebody ought to tell Mr. Lapella that he can't email and tell you that and have you say something to the court that's wrong. But I'm going to go ahead and enter a not guilty plea on Mr. Pavel. We'll come back on December 9th at 9 a.m. Is Cleon Ellis here? Come on forward, sir. So, Mr. Ellis, this is case number 24 CF 2117. As I said before, you do have a right to have an attorney appointed. You wish to have an attorney appointed, you're going to hire a private attorney.
Yes, sir.
Appoint the public defender?
Yes, sir.
Okay. The court will appoint the public defender. Court's going to enter a not guilty plea in your behalf, and we'll come back on December 9th at 9 a.m. Okay? In the meantime, meet up with your attorney, okay?
All right, thank you.
There's your card right there. Kenneth Gentry. State?
Your Honor, the state will ask for a capias.
Court will issue no bond capias. Jason Koo. State. KOO.
Your Honor, the state will ask for a capias.
Court will issue a no bond capias. Leonard Thompson. Come to the podium, sir. This is case number 24 CF 2002. Again, Mr. Thompson, you do have the right to have an attorney appointed. You wish to have an attorney appointed?
Sir.
Okay, court will appoint the public defender. Make sure and fill out that form and drop it off before you leave.
Okay.
Court's going to issue a not guilty plea to preserve your rights. Come back on 12/9 at 9 a.m., okay?
Thank you.
Meet up with your attorney in the interim. Is there somebody else out in the gallery who thinks they have a hearing this afternoon? Would you, what is your name, ma'am? Come up here and talk into this mic. No, microphone. What is your name?
Suzanne Bourgeois.
Suzanne Bourgeois, do you have information?
Yep, there it is, Mr. Medina.
Talking
Who's-
with
who
his
is he?
clients.
Pardon? Okay. Your client, well, I know you haven't spoken with him, but he's been appointed, so we gotta wait for him to come out, so just hang around, we'll deal with it.
Okay.
Okay, I just trying to get people who don't have attorneys. You've got an attorney, and he'll be back out, so.
Okay.
If you'll go back and sit down, we'll call your name in just a second. Anybody else who thinks they have a hearing this afternoon?
And Your Honor, can we readdress Mr. Jason Koo?
Sure.
It looks like Mr. Brad Stewart had filed a waiver and a written plea of not guilty in that case.
Okay. Court will. Thank you, counsel.
Yes, Your Honor.
I guess what we should do is have the state check that before we issue before you ask for a no bond capias. So, but I neglected as well, so I'll take equal responsibility. We're going to enter a not guilty plea on it's already been entered, not guilty, but we'll come back on 12/9. Okay. That's all I've got for out of custody, Mr.
I've got 4 unrepresented inmates.
Okay, let's do it.
I got Ms. Frazier first.
Okay.
Ms. Frazier?
What's the name again?
Samantha Frazier.
Frazier. So, Ms. Frazier, this is case number 24 CF 2007. Today's hearing, ma'am, listen to me. Today's hearing is an arraignment. The whole purpose of today's hearing is to make a plea, but you do have a right to have an attorney appointed. Is that what you gave her, a form to fill out? Is that what she's looking at?
No,
What
so
do you-
that's our information.
Pardon?
It's the information from the state we have to pass out.
Gotcha. So, you do have the right to have an attorney appointed to assist you with this case. So my first question is, before you take a plea, do you wish to have an attorney appointed? Yes?
sir.
Okay. The court will appoint the public defender, and the court, I'm going to go ahead and enter a not guilty plea on your behalf. That preserves your rights until you have a chance to meet with your attorney. And we'll come back on December 11th, 9 a.m. That's the next pretrial. In the meantime, you'll meet up with your attorney and kind of figure out what your options are, okay?
Okay, thank you.
Thank you.
Next will be Elijah Anderson.
Okay?
Elijah Anderson.
Mr. Anderson, this is case number 24 CF 2132. Purpose of today's hearing is merely to enter a plea. This is the arraignment day. But I note that you do not have an attorney. You do have the right to have an attorney. If you cannot afford one, one will be appointed for you, or you can hire a private attorney. Do you wish me to?
I was gonna see if there's any way that we could settle this today and just,
I'll ask the state if they have an offer. See what it,
Your Honor, Mr. Sprouse has stepped out, so give me just a
you
second.
want to wait it? Do you have it?
I'm gonna take a look at the case, Your Honor.
I know that my father.
Hold on, wait. We'll get you, see if they've got one, but the state attorney just stepped out, who just happened to be handling your case.
Your Honor, the offer is, I'm just confirming this was the
Sure.
exact case. Adjudication of guilt, 6 months, Okaloosa County Jail.
You might, seems that they're only offering you an incarcerative sentence, you might want to accept the public defender and have a chance to meet with them and see what, if you have any, what your different options are, okay?
Okay.
The court will appoint the public defender, and I'm going to enter a not guilty plea on your behalf. That preserves your rights by entering a not guilty plea, and then we'll come back on December 11th. In the meantime, you can meet up with your attorney and look at different options, see what they can do. They might have some discussions, or you might talk about any defenses you might have or whatever, okay?
Okay.
Okay, thank you very much.
Next is Gus Curley. Curley. Is podium set?
This is his turn, Curley.
Mr. Curley, this is case number 24 CF 1985. At this point, today's hearing is just an arraignment to make a plea. I note that you do not have an attorney. You do have the right to have an attorney. We can appoint.
Take care of it today, Your Honor.
You're going to appoint, you want me to?
Yes, sir.
Okay. So the court will appoint the public defender,
Yes, sir.
and I'm going to enter a not guilty plea in your behalf today so it can preserve your rights.
Judge,
And
they
the-
offered him a plea, he's holding his plea.
Yeah,
Oh, you're holding
I'm gonna
the
take the plea, Your Honor.
Okay?
Yes, sir.
Okay, I didn't know they gave you
Yeah,
an offer.
I'm sorry, Your Honor.
Me-
I'm sorry, Your Honor, it's my fault, I couldn't take
That's
it.
all right.
Can I approach the defendant, and I will take care of it while Mr. Sprouse
thank
is
you,
taking
ma'am.
care of it. Did he sign this?
It's over there. Oh, boy, way too much now. Yes, sir. Thank you, Your Honor. I have 30 days to pay this.
Just a second, sir, and
I
Mr.
got
Medina?
plenty. I can pay it.
Mr. Medina,
Yes, Your Honor.
while they're done, did we handle Donald Alloway
Thank you,
Going
Jim.
to, Your Honor, we have a plea deal for Mr. Donald
Okay.
Elway
I'll take it, my
and for 3
son.
other inmates. And we also have the gentleman laid over from the morning,
Okay,
Anthony Allen,
okay,
a deal ready to go.
okay. We've got just a couple that are without attorneys, and then we'll do all yours, okay?
Yes, sir.
Your Honor, it appears that in this case, in Mr. Curley's case, that Mr. Curley and Mr. Sprouse have entered a plea agreement.
I'll find out who that
In
is.
count 1 of the information, Mr. Curley is charged with driving while in habitual traffic offender status. The agreement between the defendant and the state is that Mr. Curley will plead to a lesser included driving while license suspended or revoked. The statutory cite to that is 322.32, and it's paragraph 2, subparagraph 6, subparagraph 1. That will be an adjudication, $300 in court costs and credit for time served. The defendant will plead to count 2. He will be given a withhold of adjudication on that count and $270 in court cost. And count 3 will be dismissed by the state, and that is the entirety of the agreement between the parties.
What's the Senate, on count 2, what is
A withholding court cost, Your Honor. A
withhold, the credit for time served?
Yes, it would be.
Okay, you didn't say that.
Yes,
That's
a
all right.
withhold credit for time served in the
Okay,
court cost, Your Honor.
gotcha, that's,
And Mr. Curley, if he wants to accept this, does need to sign this.
Yeah, my son here. Okay, thank you. I appreciate you. Thank you, Your Honor.
Only one court costs in the amount of $300.
Thank you, Madam Clerk.
Thank you. Is there anything else on the sign?
Your Honor, can I approach the agreement? So
You may.
Thank you, Your Honor.
that's all right. You can thank the state. I didn't have anything
Thank
to
you,
do
Mr.
with it.
Kendrick. Thank you.
Okay, did Mr. Curley just sign this?
Yes, yes, sir, I signed it.
Okay. I just wanted to put the right date on. Okay. So, Mr. Curley, I just need to ask you a few questions, okay?
Yes, sir.
Raise your right hand. Do you swear
sir.
or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor, I do.
Okay. So I just want to make sure you just signed this plea agreement, and the state attorney, who's not your attorney, but
Yes, sir. I think all
represents
you.
the state, was laid out the terms of the plea agreement. Just want to make sure that you're comfortable with those.
Yes,
And, you know, there's some legal stuff in here, and I just want to make sure you're comfortable entering into this plea agreement.
Yes, Your Honor. I got an 18-month-old, I'm a single dad, and I thank you and your court all for your hard work, and I'm sorry to be here, but I am, and I know y'all got a job to do, and I thank you so much for having mercy on me.
So you understand that by entering this, you're waiving the right to go to a trial, and
Yes,
this will
sir.
be a final resolution of your case. You comfortable with all this?
Yes, Your Honor.
Okay. Well, based upon that testimony, the court will accept your plea, and you can put your hand down. So as to count 1, the state has offered you a lesser included. There'll be an adjudication of guilt on that driving on a suspended, $300 court cost. The actual sentence will be credit for time served, which
Yes, sir.
means you don't need to serve any more. Possession of paraphernalia, which is count 2, is withhold of adjudication. That's also credit for time served. And you said that 270 does not apply, just the 300? Okay, so I'm crossing that 270 out, it's only 300. And then the third charge, plate not assigned, is just being dismissed as part of this plea. Okay?
Yes, sir, thank
So
you.
you'll be able to get out immediately, and you've got 180 days to pay the court costs.
Amen, thank you. I was thinking about 30 days, but I got money. I can pay it as soon as I get out, Your Honor.
Okay, very good. Okay, thank you very much. Good luck.
Thank y'all very much. God bless.
She's covering for you, Ken.
Yeah, thank you, Judge.
That's all right. That's the way it happens as soon as you leave the courtroom. You got to be called. You sit here all morning and not be called. Okay, Mr. Houston, the purpose of today's hearing is called an arraignment. This is case number 24 CF 2158. Purpose is just to make a plea. but you do not have an attorney. So you do have the right to have an attorney. And so before we start, I wanted to ask you, do you wish to have an attorney appointed?
Yes, sir.
Yes, okay. So the court's going to appoint the public defender. I'm going to go ahead and enter a not guilty plea on your behalf. That preserves your rights, okay? Gives you a chance to meet up with your attorney in order to look at your different options. So we'll continue this matter until 12/11, December 11th. In the meantime, your attorney will come visit with you and look at your different options.
And, Your Honor, just for the record, is there an
Sure.
offer for Mr. Houston to consider?
Not at the moment.
Okay, so hopefully there'll be an offer coming soon on that, and your attorney will look at it. Does the state anticipate making some offer?
Yes, Your Honor, the state anticipates making an offer.
I know you have, I know, but you're gonna get one in the next week or so?
Absolutely.
Okay. Very good. So, not guilty, come back on the 11th. In the meantime, are you his?
Yes, Your Honor.
Is they 8 years, Mr.?
Yes, Your Honor, it'll be
I can't believe I've
mine.
been doing this for 3 years and I still don't know where the alphabet is.
Yes, Your Honor, it would be mine.
Okay, so that'll be your attorney, so he'll come out and visit with you and look at different options. Hopefully get a resolution. If you do get a resolution, Mr. Gates, you're
Yeah, let
welcome
me-
to put it on a miscellaneous date and
So
try and get
just-
it done earlier.
I looked, and Mr. Houston's not actually from the state of Florida. He was here on, I guess, on vacation. Is the state inclined to consider a probation offer? Not today, and if that's the case, then maybe we could get a bond, a signature bond for him to let him out pending that. Because I'd hate to keep him in custody for another 2 months, especially if he's not from the state of Florida.
The state would stipulate to a lower bond.
It's, what's the
What is the
$2,000?
current bond?
$2,000 cash for professional and ROR on count 2. And I didn't see anything in pretrial services documenting showing that he, I mean, they don't have much access, but I didn't see anything as far as criminal history for him, and they recommended a signature bond in both cases, or both charges.
The court will grant the request for a change in bond. We're going to make it a $2,000 signature bond, means you can get out on your own signature. If you don't come back, then they'll hit you with an additional $2,000. The only thing I would say to you, if you're out of state, make contact with your attorney. You know, before you leave, try and talk to him. Don't put your head in the sand on this.
Yes, sir.
Got to deal with it. Don't go back to Texas and forget about this, because sooner or later it'll come back and bite you right in the rear, okay? So
Yes, sir.
this is not the most serious crime we've dealt with here today, but don't ignore it, okay?
Yes, sir.
But you'll be able to get out. The other one's an ROR bond, right, Madam Clerk?
Yes, Your Honor.
So it'll allow you to get out today, okay?
Yes, sir.
And would
Okay.
would the court allow him to be released on the minutes?
Sure. Yeah,
Thank you, Your Honor.
okay.
Thank you.
Good luck. Is that the last inmate with,
Out of the unrepresented, I think that was the last one, Your Honor.
Yes, sir.
okay? So, Mr. Medini, you want to, I think you got, you
Yes,
want to start just
I
alphabetically?
have
Mr.
one out of custody.
Okay,
I needed to let I gave some bad information on one person she was reaching out to. May I have your discretion for the indulgence for just one moment, Your Honor?
sure. Are you going to call Ms. Bourgeois?
Yes, Miss Bourgeois, or
Miss
how do you
Bu-
say it? Okay, thank
Ma'am,
you.
you can come forward again.
And Your Honor, I'm giving Miss Bourgeois my card with my assistant's name on it. She does need to complete the public defender application and turn it in to the clerk's office on the first floor, is my understanding.
Do we have a form for her?
Yes. And at this time, Your Honor, Ms. Bourgeois would, in 24 CF 2184, plead not guilty. She's going to set an appointment, and she's going to complete this application before she leaves the courthouse and turn it in on the first floor, okay?
Okay.
Thank you very
The
much.
court will accept your not guilty plea, And we'll come back on the 9th of
Judge.
December at 9 a.m.
If I may briefly relay an offer, I don't believe it was relayed to defense.
Was it
Ma'am, you want to
1129
listen
probation?
No.
to this?
It's a withhold 270 court cost credit for time served.
Withhold,
And that's on a POP offer as well.
oh, on a POP. Ma'am, have a seat. We may want to talk.
I should have spoke up earlier, Judge.
Oh, that's okay. Well, it's okay with me. I don't know if it's okay with the court. But, Judge, she may want to talk
Sure,
about
I
that.
understand. You're the last man standing though, so.
I've got some inmates ready to go, so I can do my inmates, with some of them have pleas, and then I can talk to her, and that's pretty much it.
Okay,
I can also take my inmates, if that'll give Mr. Medina some more time as well, Your Honor.
okay, you want to do that first? You want to,
What do you want to do?
whatever's most efficient.
I think calling my inmates would probably be very efficient. I've got
Okay.
3 plea agreements, so we can get them done, and
Very good.
1 continuance of an inmate. Thank you. Your Honor, first up is Donald A. Alloway. Thank you, sir. And Mr. Alloway's before the court at 24 CF 2151. Can the court see that on the docket? I'm
I do,
sorry.
I've
Okay,
got it, thank you.
Thank you, Judge.
Yeah, I've got it.
Your Honor, we have worked that case out. The state will be submitting a score sheet, because I don't have a score sheet at the moment. But we have an agreement worked out. I'm sorry.
It's a lesser included.
Alloway,
Yeah.
Donald, we will need to have the state submit a score sheet. I don't have anything to print
Lesser
out.
included of POP.
Oh, it's a lesser included, a POP. Okay.
So it's a misdemeanor, so it does not require.
I apologize. Let me.
That's all right.
So it'd be adjudication credit for time served, 270 court costs.
I'm sorry. That was my mistake. Let me get the statutory reference, Judge.
Okay.
That's much better. I have a feeling I have to make that change on somebody else's agreement probably, which is a good thing. Okay. Apologize, Mr. Sprouse. Thank you for pointing that out.
Yes, sir, I see it, sir.
So, let's,
All right, thanks, sir.
okay, there you go.
Today's date, 17.
Yes, sir, 10/17/24. Okay, thank you. All right. Thank you. May I approach, Your Honor?
May. Thank you.
Thank you.
Would you announce?
Yes, Judge. Donald A. Alloway and 24 CF 2151 will be entering a plea of nolo contendere to a adjudication of guilt to a lesser included offense, possession of drug paraphernalia, first degree misdemeanor. Statutory reference is given. Credit for time served. 615 court. That's going to actually change in his favor down to 270 court costs. I apologize, Judge. Shall I make that?
I got it. I got it.
270 court costs rather than 615.
Yes, sir.
Okay.
So
And you got 6 months to pay.
6
Very
months
good.
to pay and 150 public defender fees.
Yes, sir.
State agree, is that the agreement?
That is the agreement.
Mr. Alloway, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state, it's obviously a good deal, adjudication of guilt. You'll get credit for time served. That's technically the sentence.
Yes, sir.
That means you get out today,
Yes, sir.
okay? And you've got the court costs and fees. You got 6 months to pay them.
Yes, sir.
So you do understand this will be obviously final resolution here, but you're waiving the right to go to a trial. Is that what you want to do?
Yes, sir.
Okay. Based upon that, the court will accept your plea. There'll be an adjudication of guilt to the lesser included charge of possession of paraphernalia, and the site is in the agreement. Court is sentencing the defendant to credit for time served, and then $270 in court costs, $150 in PD fees. You got 6 months to pay before it goes to collection.
Yes, sir.
Good luck, sir.
Thank you.
Good luck, sir.
What's your next case?
Andrus.
Andrus?
Your Honor, Brett C. Andrus is approaching at 24 CF 2157. Your Honor, he has 2 VOP cases, to my knowledge, 24 CF 756 and 23 CF 2765. I think they're on the docket for this coming Tuesday, October 22nd. So he will enter a plea of not guilty on this case, and we're going to try to work out a global deal on Tuesday. I do note that the state said that right now it would be a DOC offer, but that it was talking to the alleged victim. I also have some information for Mr. Andrus, so we'll talk and try to resolve it.
So we'll continue to bring it back on the 22nd along with the 2 VOPs?
Yes, Your Honor, that would be ideal.
Very good. The court will enter a not guilty plea on his behalf to preserve his
Thank
rights.
you. Okay, thank you.
James Balaz.
Balaz, yes, sir. Thank you. I'm just pulling out your score sheet, okay?
This is case number 24 CF 2159.
Yes, Judge, and we have an agreement that I've been over with Mr. Balaz, and there will be a score sheet, which I have, so pulling that out, just showing him what that score is going to be. And he advises that he has a VOP, and I think it's Santa Rosa County, so I've advised him. I have no idea what will happen over here, but he thinks this is in his best interest. May I approach with the agreement, Your Honor?
You may. Yeah, we don't, if it's in different counties, we don't have control over that, so it's just, want to make sure it's clear that the 2 are not linked. You want to announce the case?
Yes, Judge. Just pulling it up on my phone here. It's James L. Balaz, B-A-L-A-Z-S, in 24 CF 2159. Pursuant to agreement is entering a no contest plea with an adjudication of guilt as charged, credit for time served, $615 court costs, $150 PD fees, monetary obligations to collections after 6 months.
That is the state's agreement.
Mr. Blas, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the true self you got?
Yes, sir.
So you heard the attorney state the terms of your plea agreement, pretty straightforward. It's credit for time served agreement plus fees and costs. Have you read? Okay. Got to get me a signed one, Mr.
Oh, I'm sorry, Judge.
It's all right. I think you might need to sign it too.
Yes. Okay. You ready to sign?
Yes, sir.
Okay. Thank you. Thank you. Thank you. Yeah.
Mr. Benito.
Thank you.
You're welcome, sir.
Thank you. So, Mr. Blas, you signed the plea agreement and that your attorney explained I just want to make sure you read the agreement, gone over it in detail with your attorney. You understand that by entering this as a final resolution of your case, but you're waiving the right to go to a trial, and you're waiving some other legal rights.
Yes, sir.
Okay, you believe that's in your best interest?
Yes, I do.
And you're entering this freely and voluntarily?
Yes, sir.
Very good. Based upon that, the court will accept this plea agreement. There'll be an adjudication of guilt on both counts, and the court will sentence you to credit for time served.
Yes, sir.
That means you can get out immediately. There are $615 in court costs, $150 PD fees. Got 6 months to pay this before it goes to collections.
Yes, sir.
Okay, any questions?
No, sir.
State will provide a score sheet since this
Very
is.
good. Thank you.
Daniel Barrow.
Your Honor, I did not realize that Mr. Barrow is in custody. They usually have a red dot if they're in custody, so that's why we were looking for him. Your Honor, at this time, does the state have an offer for Mr. Barrow?
No, state has not talked to the victim, which we need to do
Okay.
to comply with Marcy.
I did go up there yesterday and I filled out paperwork to say that I did not want to press those notes.
Okay.
I haven't had a chance to review it. I could have time, just haven't since yesterday we've been in court.
Do you think it would be good to pass him briefly today to give the state a chance to talk to her, or should we?
I can talk to them now.
Excuse me, ma'am. I apologize, Your Honor. May I address the prosecutor? I know that's not
Sure.
the way things
Sure.
should normally work.
No.
Should we bring him back on the 22nd, or can you talk to you?
I can talk to her right now,
Okay.
I apologize.
just to expedite.
Being out of form here. Set Mr. Barrow aside briefly.
fine.
Thank you. So go back there and we'll see what we can do. Okay.
You want to go talk to her? We'll
Yes.
cover it for you.
Thank you, Judge.
Ms. Sharpless is poised.
I have a list, it's all in alphabetical order.
Okay. Or Ms. Giardini. Either one.
Either one is fine.
Your Honor, this is Mr. Anthony Allen held over from the morning.
Right?
We have an agreement that he is signing. Let me just make a couple changes, didn't mean to touch your plan.
You're quite all right.
Just want to make sure.
I'll borrow that and then I'll let you keep it, okay? May I approach, Judge?
You may.
We do not need a score sheet because it's a reinstatement and modify. I'm just showing him what a score is.
All right, sounds good.
May I approach, Judge?
You may.
Oh, I'm jumping the gun, nobody's signing things because I'm, you ready to sign?
Yes, sir.
Okay.
Yes, sir.
Thank you. This demeanor was already expired, but I'm putting time solved on served on there, so it's dealt with. Thank you. May I approach Judge? There, no score sheet because it's for reinstatement.
Thank you.
Your Honor, under the terms of the agreement, Anthony D. Allen in 21 CF 282 will be pursuant to agreement admitting the violation. He was previously adjudicated guilty. We were asking to reinstate and modify the supervision. That's as to the felony. The misdemeanor was a second-degree misdemeanor that long ago expired, but I put on there time served, so there is a sentence to make that go away. But on the felony, the supervision will be extended for 1 year. So I think it's going to have a 2026 expiration date, with the remaining supervision to be drug offender probation, 9 p.m. to 6 a.m. curfew, special condition of bars to bed Phoenix House, completed original terms and conditions, $100 VOP fee, 150 PD fees.
State.
That is the state's agreement.
Mr. Allen, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written agreement that you've signed. Just want to make sure you've had a chance to review this closely and go over it in detail with your attorney, make sure you had all your legal questions answered.
Yes, sir, I did.
And you understand that by entering this, you're waiving the right to go to a trial and some other constitutional rights
Right.
in order to get a final resolution of this case here today.
Yes, sir.
Are you doing so freely and voluntarily?
Most definitely.
Okay. Based upon that, the court will accept your plea agreement. There was a previous adjudication of guilt on all charges. Court, as to count 1, will reinstate and modify supervision. That's the felony VOP. The court's going to extend supervision, which is probation, for 1 year, with the remaining supervision to be drug offender probation. That has a 9 p.m. to 6 a.m. curfew. And if you have a job or something that goes in the evening, you got to coordinate that, and they can tweak it a little bit. As a condition of that probation, special conditions, bars to bed Phoenix House, to complete the program and any aftercare. Complete original terms and conditions, then you've got $100 VOP and $150 PD fee. The misdemeanor VOP is just done. Credit for time served.
Yes, sir.
Okay, any questions?
No, sir.
Good luck, sir. 30 days to appeal this.
Your Honor, I don't know if the court wishes at this time to recall the gentleman who just stepped out. But
What was it?
I think
What was the name?
It was
Barrow, got it. Daniel Barrow, 24 CF 1996.
I think there's going to be, I think the state will need to hear from the victim on the record, and then there'll be.
Doesn't have to be on the record.
Okay.
I have just 3 questions for the victim, and I will get the case resolved, Your Honor.
Can we
You
get?
need to do it on, do you feel like you need to do it on the record?
I believe so. Yes, Judge.
Okay.
Daniel R. Barrow?
Let's, before he comes out, have the.
Right now, there's no contact with.
No, bring her up, put her on the stand. If you're gonna ask her questions, it's gotta be recorded.
But we need him to be able to be
I understand
present.
that, but I just didn't want him standing right next to her when she walks outside.
Oh, okay, Your Honor, I'm sorry.
He can hold over there. Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Ma'am, would you please sit down, just talking to that mic? Does the state have some questions? Go over to your mic. You can do it right from your table. Okay.
Ma'am, please state your name for the record.
My name is Christina Judy.
And you're an alleged victim in case number 24 CF 1996.
Yes, sir.
Do you wish to proceed with these charges?
No.
Do you have an objection to the defendant expunging his record?
No.
Do you realize the state is not going to reopen these charges?
Yes.
No further questions.
Let me step down, ma'am.
Thank you.
Thank you.
Given
Just stay right
the
there.
alleged victim's
You can go, ma'am.
statement under oath in open court, the state is going to dismiss 24 CF 1996.
Very good. State's dismissed.
Okay. You're free, you're done, but you'll have to go back to the jail to be released from Crestview. Good luck.
Okay.
And thank you, Judge. He was just incarcerated. I wanted to get it resolved.
Thank you,
That's all
sir.
right.
Appreciate it.
Yeah.
Your Honor, I apologize, I have to leave a little early today.
That's
May I
all
be
right.
excused? Mr. Sprouse is going to cover my last few cases.
Okay, as long as he covers for you, that's all right.
And Your Honor, if I may approach, I have score sheets from this morning
Sure.
that I owe you.
Thank you. So what are we doing next?
And Mr. Keys for Mr. Gates.
Okay?
This is going to be Andrew Keys for the court. Before the court in two cases, 24 CF 2099 and 24 CF 2098.
Okay?
We have a plea agreement to be filed in both cases, if I may approach, Your Honor.
You may.
This will be a downward departure, Your Honor. I would like to say announce the basis.
Judge, this is going to be a downward departure. The basis is a legitimate, uncoerced plea.
Very good. Mr. Gates, would you please announce the agreement?
Yes, Your Honor. Mr. Keys will be entering a plea of no contest in both cases and all counts. Be adjudicated guilty in all counts and cases. And 24, and I got the wrong case numbers there. I apologize, Your Honor. And 24 CF 2098. It's going to be 9 months in the county jail, concurrent with credit for all time served, concurrent with each count and with the other case, which is 24 CF 2099.
So each count gets 9 months,
Each count is 9 months,
but concurrent,
but
okay,
concurrent.
gotcha.
615 court costs, 150 public defender fee, and then in 24 CF 2099, 9 months county jail concurrent with each count, and with the other case, which is 24 CF 2098, with credit for all time served. Standard court costs, public defender fee. Mr. Keys would ask for 24 months to pay those outstanding fees before they're sent to collections.
And that is the state's agreement.
Okay. Mr. Gates, come here. Either this, these are all,
That's what I
that's what you were
referring to,
I'll just let you. Okay. Okay, is that the state's agreement?
Yeah.
State's agreement, yes?
Yes, Judge.
Mr. Keys, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of the plea agreement, and those terms are contained in the written plea agreement that I see you've signed. Just want to make sure, have you read this closely, gone over it with your attorney, had all your legal questions answered?
Yes, Your Honor.
You understand that by entering this plea agreement, you're waiving the right to go to a trial and to force the state to prove their case. This will be a final resolution of this case.
Yes, Your Honor.
Are you doing so voluntarily? Nobody coercing you to do this?
No.
Based upon that, the court will accept your plea agreement. And as to basically what you have is you got two cases, 6 separate counts. All the counts are identical sentences. They're all 9 months, Okaloosa County Jail, but they'll all be run concurrent. They'll run at the same time, and all will get credit for time served. It may be a little different from one to another, but time served, credit for time served with each one of these. You have the standard fees and court costs, and you'll have 24 months from the date of release to pay these outstanding costs before they go to collections, okay? And you have 30 days to appeal this, even though you just entered into it, okay?
Thank you, Your Honor.
Thank you.
Sheena Hall.
Yes, Your Honor, this is going to be Ms. Hall before the court at 24 CF 2077. I have a plea agreement for Ms. Hall.
Okay?
I may approach, Ron?
You may.
So they plead to reduce charge, so there'll be no score sheet here on that.
Thank you. Would you announce the terms?
And that clerk will call for that. Ms. Hall will be entering a plea of no contest to a reduced charge of resisting officer without violence, adjudication of guilt, credit for time served, $270 in court costs, $150 public defender fee. She'd ask for 24 months to pay those outstanding fees before they're sent to collections.
Do we have a statutory cite on the lesser included?
Yes, Your Honor, I do. The court will allow.
Madam Clerk, if you'll.
The site is 843.02.
Thank you.
And that is the state's agreement, Judge.
Very good. Ms. Hall, would you raise your right hand, please? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
Okay, so you heard your attorneys outlining the plea agreement, and that same plea agreement is contained in your written plea agreement that you signed. Just want to make sure
I heard it.
you've reviewed this, gone over, had any questions you had for your attorney.
I did. I'm
Okay,
good.
and you understand that you're waiving the right to go to a trial and some other valuable legal rights in order to get a final resolution. Is that what you want to do here today?
I do.
Okay. Very good. And you're doing so freely and voluntarily? Nobody's coercing you to do this?
Yes.
Okay. Very good. Thank you. And the court will accept your plea agreement. There'll be an adjudication of guilt to the lesser included charge of resisting without violence. The actual sentence is credit for time served, so you'll be able to get out immediately. There are standard court costs, $270 and $150. And you'll have 24 months from the date of release in order to pay it before it goes to collections.
All right. Thank you.
Any questions?
No, I do not.
Thank you.
That concludes my business for the court today, or if I may be excused.
You may. Thank you.
Mr. Gates, can we please address
What?
the other piece?
Patrick Hart?
Yes.
Yes, Your Honor. We had Patrick Hart earlier today, Your Honor, and we filed a plea agreement to be covered. However, one of the cases listed was actually closed, so it should not have been on the plea agreement.
Okay, hold on a second. What's the name on this?
It's from the morning docket, Patrick Hart.
Okay.
Probation had emailed us and asking if we could address it and they didn't.
Okay. What do we need to do?
I'm not quite sure, Your Honor. We filed, so he was put back on probation in 23 CF 1058 in May of this year. Subsequently, the court signed an order in July terminating that probation. So that should by all accounts be closed. I don't know if we just need to say that.
It seems to me that if that's been closed and it should not have been a part of the plea agreement this morning, we just make it on the record that any reference to 23 CF 1058 that was previously closed are withdrawn from that agreement.
Yes, Your Honor.
So we're just withdrawing that from
Yes,
the
sir.
agreement. Doesn't change the other one, so.
No, Your Honor, it does not.
If they need anything more, let me know. I'll sign whatever you need.
Yes, Your Honor.
Okay. Okay. Ms. Farkas, Mr. Medina, who's up?
Your Honor, I'm ready. There's one plea agreement that Molly is getting from our office for one of my, Kina Mendoza. But I'm ready on everybody else.
Let's do it. We've got a big sentencing.
Yes, Your Honor.
Starts in 10 minutes.
Yes. First up is Michael Demons, 24 CF 2139. This is just the information in your case if you want it. It's just the charges. You can have that if you want. All right.
Are you going alphabetically again, or just?
No, I was going with who he called out first.
You told me that you had something.
Yes, just Kano Mendoza, I have to give him the offer, but,
So who is this? I'm sorry.
that's okay, this is Michael Demons, 24
Okay,
CF
I got it.
2139. Mr. Demons would like to enter a plea of not guilty. I think he's on the docket for 12-9, but we can move it to 12/11.
Very good. Court will enter a not guilty plea, and we'll continue this till 12/11 at 9 a.m. What about Joseph Cottrell?
Your Honor, that case was dismissed. I think it's on the docket
Okay,
Yes,
improperly.
it was no pros on 10/15
okay, good.
by the state.
Didn't have it on mine.
Sure.
Okay. Dowda?
Your Honor, this is Troy Dowda, 24 CF, sorry, right here, 24 CF 2153 and 24 CF 2281. We'd like to enter, oh, I'm sorry. I was reading off one that is on for arraignment on November 14th that I have with this one. I apologize. The one that's on your docket right now is 24 CF 2153. If we could enter a plea of not guilty and put it on for 12/11.
Court will enter not guilty plea, and we'll continue till 12/11.
I don't know if I can enter a plea of not guilty in the other case while we're
Has
at
there
it.
been an information file? That's the only
Can you
question.
have that case number again, please?
Yes, 24 CF 2281. I believe there is.
The information is not in the account.
So you have to come back to.
That's
bring it.
okay.
Sure.
So your next court date? This is yours if you want a copy of it. Okay, I'll see you.
Now, we have, one of the defendants has listed Catherine Jaquette. I don't know who's that, that's Cabino Taylor. Who would have, who has the T?
I will try to get the answers to the court.
You left too early.
I didn't leave quick enough, Your Honor. What was the name again, Your Honor?
It's Taylor Gabino, and I'll give you a case number, 24 CF 2195. It's just got Jaquette listed as the attorney.
It looks like on October 15th, Mr. Harper filed a new notice of appearance and legal arraignment, so it should be changed to Mr. Harper now.
So it should be Harper and who, and what's the status? Was she on today? Or was there somebody, was it
He
in?
filed a not guilty plea, so he's currently set for 12/11.
Okay, so continue till 12/11, so it's covered. Mr. Gates?
Yes, Your Honor.
Thank you.
You're welcome.
Appreciate your help.
Stick around, man, we'll think of something else for you to do.
Who is this? Kano?
Your Honor, this is Jorge Cano Mendoza,
Okay.
24 CF 2131. Your Honor, the state and the defense have reached an agreement in this case. It does include 2 misdemeanor cases he has.
Okay.
I would like to make a brief statement that Mr. Cano Mendoza and I have not reviewed discovery together in this case, and I have
In
not.
which case?
I'm sorry, in 24 CF 2131, and I have not conducted depositions. However, the offer, it is a probation offer, so I understand my client's desire to accept it.
Okay,
I just want to make it clear.
okay, I'll ask him about it.
Okay. So I've had the state attorney sign it. I'm going to have Mr. Cano Mendoza sign it as well. Sorry. The date. May I approach?
You may. Thank you. Would you announce the terms of the agreement?
Yes, Your Honor. In 2024 CF 2131, there is 1 count of dealing in stolen property by trafficking, a second-degree felony. There will be a withhold of adjudication in that count, 24 months standard probation, $515 in court costs, and $150 public defender fee. In 24 MM 3250, counts 1 and 2 will both be withholds of adjudication with credit for time served. $270 in court costs, $100 public defender fee, and 24 months to pay those costs. 24 CT 1267, count 1, also withhold of adjudication, credit for time served, court costs, PD fee, 24 months to pay the costs, and the state will take no action on the failure to appear in that case.
Your Honor, that is the state's agreement.
Okay. Would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see those terms are in writing that you've signed. So I just want to make sure, have you read this closely and gone over it with your attorney to make sure you have all your legal questions answered?
Yes, sir.
You understand that by entering this, you're waiving the right to go to a trial, and this will be a final adjudication of all these cases. Do you understand that?
Yes, sir.
You believe that's in your best interest to accept this deal here today?
I believe so.
Okay. Nobody threatened or coerced you to get you to enter into that, have you? Okay. Very good. Based upon that testimony, then the court will accept your plea agreement. In 24 CF 2131, the court will withhold adjudication, sentence the defendant to 24 months standard probation with the $515 in court costs and the public defender fee. In the misdemeanor cases, there's 3 counts, 2 in 24 MM 3250 and 1 in 24 CT 1267. All of those have the same sentence. The withhold of adjudication, and the sentence is technically credit for time served. So you're done with those. They all have standard court costs and fees. You've got 24 months. We actually should have those roll into the other probation. So you've got to pay those during the term of your probation, all your fees and costs, okay?
Yes, sir.
That means as long as you're on probation in this the felony case, you'll have time. You have that whole time to pay.
24 months.
May I approach?
Thank you. So do you have any further questions?
No, sir.
Okay. Good luck. Is there a score sheet in this? Score sheet?
I can, Your Honor, the state will send it.
Not a downward
It is
departure.
not a downward departure, Your Honor.
Okay. Thank you.
Thank you.
Actually, I have one. It just doesn't have the misdemeanor from it.
Just put
Yeah.
misdemeanor times 2 and put 0 points.
Okay, here.
So are we, I think that's all on my list. Mr. Medina, we good?
I'm ready to go with Ms. Bourgeois,
Okay,
if that's okay,
yep.
Your Honor, Suzanne M. Bourgeois is before the court in 24 CF 2184, and all parties have signed an agreement for a misdemeanor resolution, and I'm just making a copy, Judge, I'm sorry. May I approach?
You may. Thank you.
And I do want the court to be aware that Ms. Bourgeois advises me that she's on prescription medication that helps her to understand what she's doing and does not inhibit her freely and voluntarily and knowingly take a plea agreement today.
Okay, very good.
In 24 CF 2184, Ms. Suzanne M. Bourgeois, Bourgeois, will be resolving her case as follows. There would be a nolo contendere with a withhold of adjudication on count 2, which is a misdemeanor paraphernalia charge. Count 1 is actually going to be dismissed by the state. There will be $270 in court costs, $150 PD fees, monetary obligations will go to collections in 6 months.
That's the state's agreement.
Very good. Bourgeois, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
So I see that those same terms of the plea agreement that your attorney just spelled out are in the written agreement that you've signed. I just want to make sure, if you read this closely, you've heard my speech,
Yeah, I
you've
read
repeated
it.
it already. So, read through this, asked as many questions you need to. You understand this will be a final resolution in your case today?
Yeah.
Okay. You believe this is in your best interest?
Yes.
Okay. Based upon that, the court will accept your plea. The state has agreed to dismiss count 1, so that's being dismissed. That's the felony. The misdemeanor, possession of paraphernalia. There'll be a withhold of adjudication. You got some standard court costs and fees, and obligations go to collections in 6 months. Okay?
Okay.
Thank you very much.
Thank you, Your Honor.
Thank you.
Okay. So we good?
Yep.
Okay.
Don't worry about that at this point.
I know we have a sentencing that's starting, like right now. We've been at it since lunch and all morning, so if you don't mind, I'm gonna take just a short break, maybe 10 minutes, and then we'll launch, and I'll give everybody a chance to reconfigure their tables and whatnot.
Your
Okay?
Honor, I think public defender, at least I'm done, and I'll be excused if I may.
Absolutely.
All rise, please.
1045. CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Oh, not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Quero
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Terrence Mitchell presiding. Please be seated.
Okay. Would council approach?
Yes, sir.
So, we're here today on the sentencing for Jaden Brooks in case number 23 CF 1973 and 23 CF 1974. It's actually not a preliminary, it's a central matter, but it's preliminary to some of the other, kind of from a procedural standpoint. Obviously, the defense is going to be arguing for and has filed a motion for youthful offender classification. I just want to ask what the state's position is. Does the state disagree with the contention of the defense that the trial court has the discretion to impose the youthful offender sentencing, even based upon the crime? Or
Your Honor, the defense's sentencing motion is correct that Mr. Brooks would be eligible for youthful offender, and if the court exercised the discretion that it has and thought that Mr. Brooks is eligible and the court should give him youthful offender, Mr. Brooks could avoid the minimum mandatory. Okay. If he was giving youthful offender, that's the only way to avoid a minimum mandatory.
I just wanted to make sure that, because that's what Mr. Nopes was arguing, I just wanted to make sure there wasn't a legal argument otherwise as it relates.
There is no legal argument otherwise, Your Honor. That is correct from my understanding of the law.
And the court is well aware that the youthful offender status or classification carries with it, importantly, or perhaps critically, the 6-year mandatory sentence. And I just want to make sure we're all clear that goes from the original arrest or from his incarceration.
That the 6 years would include the credit he already has, Your Honor? Yes, it would.
Your Honor, we agree that's the law.
Okay. So we're actually dealing with, if the court would impose it, it would be less than the 6 years from today. Okay. I just wanted to make sure that we're not arguing over legal things. That I know we got it hard.
So the court would if the court found that youthful offender was appropriate, the maximum sentence would be 6 years between Department of Corrections, probation, or a combination thereof. So, yes, and it would include, if it was Department of Corrections, it would include the credit the time he's already served.
It would be credit for time served. Okay.
And
I
Judge,
thought
I
that
think-
was the case. I just wanted to make sure there weren't any legal arguments otherwise.
And I think it has to be a combination of either 2 years Department of Corrections followed by 4 years probation, or 4 years Department of Correction, youthful offender, followed by 2 years probation. It has to be a combination to equal 6. I don't know that you can put him in for 6 solid years with credit for time served findings. I think there has to be a probation factor in there, is my
So there has
understanding.
to be a minimum, what you're saying is that if there is a youthful offender classification, court would be required to have a minimum of those 6 years, at least 2 years probation.
And Judge, I don't speak at 100% that I'm right. That's my understanding. I just haven't looked.
Well,
at
you're
it.
the only, you all are the ones that are arguing it, so. Ms. Sharpless?
I'm sorry, Your Honor, I knew that the letter to the court had, addressed that, and the statutory site, the 89504, which is the statute, a designation of the defendant as a youthful offender would restrict defendant's maximum possible sentence of probation, prison, or a combination thereof to 6 years. So
That's a different question. I'm asking a specific question. Honestly, I wasn't aware of the mandatory nature of the probation. I was aware of the 6-year limit. I mean, that's one of the main functions of it.
I was under the understanding, Your Honor, that he could be sentenced to 6 years, but I would have to look that exact question up.
Judge, I think that you may impose a split sentence.
And I do know I may, but that's why I was asking. I was not aware of that of the 6 years, that as I understood your understanding, that it required a split sentence with a minimum of 2 years of probation. I know court can do that.
Yes, sir. Judge, and I'm fine with that. I mean, I understand. I think Ms. Farrakis just looked it up and told me that the court may split.
Okay, very good. Which was my understanding of, but you all have done a little more research on it than I have.
I apologize for
That's all right.
interrupting, Your Honor.
Judge, I think actually, and Ms. Farrakis looked this up, and she was nice enough to hand it to me, so 95804.
Your Honor, it's
2C.
Yeah.
Go ahead, Mary.
So just reading the statute, I'm just fine. It's okay, I just.
Well, I mean,
No, it's not my case. I was just providing the statute, that the second part of that section.
Well,
of the
why don't I, you think you can tell Mr. Noakes, I don't think you should argue.
Yeah. No.
Your Honor, I'm rereading the statute again.
Hold on. Sounds like Mr. Nopes is correct.
So Judge, I'm looking at 25804 2C, and it says that the court may impose a split sentence whereby the youthful offender is to be placed on probation or community control upon completion of any specified period of incarceration. However, if the incarceration period is to be served in a department facility other than a probation and restitution center or community residential facility, such period shall be for not less than 1 year or more than 4 years. So I think what she's found is handed me the statute suggests that if you're going to put him in prison, that it can't be for any more than 4 years.
Hold on a second. Hold on.
Read Part D.
Huh?
Read Part D.
Oh, we got to read Part D.
Mm-hmm.
Ms. Sharpless.
Your Honor, I think if you also read Part D, it says, it again lays out that the court may commit the youthful offender to the custody of the department for a period not more than 6 years. I think that these sub-paragraphs are laying out the court's options. So I think that it really is a combination of 4 and 2, 2 and 4, or one incarcerative sentence of 6 years, but the whole period may not exceed 6 years. So if it is a split sentence, it still may not exceed 6 years is how I'm reading the statute. So the court has many options if it was going to do youthful offender, which obviously the state's going to be arguing the court should not.
Right.
But
No, I understand.
Judge, in reviewing the statute and taking all the paragraphs, sub-paragraphs together, I believe that the court can give him a 6-year sentence, youthful offender, in Department of Corrections. It's only if you impose a split sentence, then you can't put him in for more than 4 years.
that's correct. That's how
That's court's read on it too. Okay. And the court will, if based upon arguments, not results, but anybody that's arguing that'll be, you can consider that a preliminary ruling that is the options that the court has. Okay. Wish to make opening remarks?
Your Honor, the state will reserve.
Your Honor, defense will reserve.
Okay. You wish to call?
Did the court get the report from Dr. Harper?
I did. That's why I was
okay. Sure.
A little later coming back here because it was just put on my desk late this morning.
I got it after hours yesterday, and I emailed it first thing this morning. Of course, that didn't particularly help you or the state because I know y'all were in court all morning. So,
so yes, I have, and I have reviewed it. Reviewed the...
Judge, I'd call Dr. Harper.
Madam Clerk, would you please swear the witness?
Do you swear affirm the testimony you have to give the truth, the whole truth, and nothing but the truth? I do. Thank you.
Your Honor, for this particular witness, the state and I think the defense have agreed that she's qualified to render the opinion.
Very good.
If you would, please just tell us your name.
Dr. Julie Harper.
And Dr. Harper, did you evaluate Jaden Brooks?
I did.
Okay. And did you render a report?
I did.
Okay. May I approach Your Honor?
You may.
Exhibit A. Do you recognize that?
I do. This is my report.
Judge, we offered that evidence what's been marked as Exhibit A.
And is that the report that I have also, the report date of 10/16/24?
Yes, sir.
Okay, very good.
I think I have to actually put it into evidence.
Yeah. Any objection?
No objection.
Without objection, the court will admit that into evidence. Call it Defense's Exhibit 1.
So, Dr. Harper, in regards to Mr. Brooks, you did the evaluation. Did you meet with him?
I did.
Okay. Did you review the arrest reports in each of the cases?
I did.
And did you talk to anybody other than Mr. Brooks about this event?
I interviewed my grandfather, which is Pastor Brooks,
Okay.
not about the details of the case events, but rather to gather the psychosocial history of Mr. Brooks.
Did you kind of arrive at the events that transpired? How did Jaden end up with his grandparents?
Well, early in his life, I think he was around 3 months old. He was being raised by his teenage mother, who Pastor Brooks described as having a drug problem. He was left in, a situation that was not safe for him. A friend of the mother called. He was going to be placed in the care of Department of Children and Families. They looked for other ways to shelter him, and his grandparents were appointed guardian.
And has Jaden been with his grandparents the whole time, as far as you know?
Yes.
Okay. And based on what you talked to his grandfather about, did his grandfather indicate that up until this period of time when these events, these two cases occurred, that they had had any problems with him being involved with the law or problems with beating people up or anything like that?
No, he described his grandson as a student athlete who is regularly participating in church, that other people noted his kindness towards their own children and grandchildren, so he did not describe any of the kinds of behaviors that were part of this case.
So was the description of what his grandfather described was just like any other kid growing up in their teenage years?
Pretty much, yes. He did describe that as the teenage years progressed, he noticed that his grandson was exhibiting some mood changes and mood problems, and that is something that he was worried about because there is a family history of bipolar disorder.
And based upon the family history that you reviewed, does it appear that there is family history of mood swings and other behavioral issues?
Yes, so there's a strong family history of bipolar disorder in the maternal side. He was also describing some psychological issues of Mr. Brooks' two cousins who have autism spectrum disorder, and that can have accompanying mood issues as well.
Now, was Mr. Brooks ever diagnosed with being bipolar?
No.
Has he ever been diagnosed as being autistic?
No.
When you first met Mr. Brooks, was there anything with your training and experience, anything about him and how he acted when you met him that said this guy or this child is suffering from this, and what, if you could just describe that for the court?
Sure. So one of my first positions as a psychologist was in a group practice called neuroeducation. That was a practice involved with a lot of assessments of kids with autism, Asperger's disorder is the way they used to call high functioning autism, OCD and ADHD, and I did social skills groups with those individuals and a lot of testing on their referrals from the military base. So when I met with Mr. Brooks, I observed during the mental status examination and then later in the interview that he had two mannerisms that would be consistent with autism spectrum disorder. Those were a tendency to repeat himself in a way that's similar to like a speech disorder, a disorder of speech, and that you've got that repetition, and then secondarily, he maintained a stiff body posture, and there was a certain way that he, I'm folding his arms, I guess, underneath himself so that in his armpits, and that mannerism is very consistent with individuals I've examined before and concluded they had Asperger's.
And did you reference that in your report?
I did, in the mental status observations only.
And did Mr. Brooks explain to you or talk to you about any of him in middle school and any of the problems that he was experiencing and how he felt about those things?
Yes. He described in the 6th grade having some social, I guess, reactivity. His peers were teasing him because he has a condition called hydrosis, which is excessive sweating. Excessive sweating is also a symptom of generalized anxiety disorder. And so because he would sweat unnecessarily even through the school day, he was starting to have peers make fun of him and generating, anxiety for him about how he would fit in. He had difficulty sleeping, muscle tension, a lot of classic symptoms of anxiety. I don't think that he recognized that it was anxiety. I think that he thought he had a genuine medical problem and asked for help in general. When we reviewed all of the symptoms that he was experiencing with like the sleep disturbance, it's very difficult for him to fall asleep because his mind is overly worried and active. It was my conclusion that those are symptoms of generalized anxiety disorder.
Do you know if he ever received any medical attention or any psychological attention?
Well, I believe that Dr. Manuel was assessing the hydrosis symptom. That was confirmed by his grandfather, that they did consult the doctor about that. But I do not think that the psychological component was ever addressed.
Based on what you observed of him and the information that you gained through this evaluation, do you believe that Jaden suffers from a mental health issue that's unrelated to substance abuse, for which he would be amenable to some type of treatment?
Yes, I think that he has two conditions that began early in childhood. Those would be the generalized anxiety disorder that I've described, and then based on his description of the school feedback to him about not being able to focus well, having difficulty staying seated, talking out of turn, I think that he has a attention deficit hyperactivity disorder. Most likely in early youth, that would be combined type. As a person ages, they become less hyperactive generally, and so he's more of the inattentive type at this time.
What was the first?
Generalized anxiety disorder.
Okay, thank you.
At this time, he has adjustment disorder with depressed mood, and it was my conclusion that he is struggling with low self-esteem and some depression symptoms, that the onset is since he's been in the jail, and so adjustment disorder is something that any of us could qualify for if our coping skills aren't up to the stressors we're experiencing. He knows he needs help for the anxiety. It is affecting him in that he can't sleep. It's very uncomfortable. It's hard to focus, and he can't really reduce the worrying. So we discussed that, and I do feel that he's amenable to treatment in that issue.
And are you aware of how old he was when these two cases occurred?
He was 15.
Okay. And he'd be 16 now?
Yes.
Okay. Do you believe the fact that he was 15 might have played a part in his thought process as to whether this is something I should do, shouldn't do, or what have you? Do you have any opinion about that?
I definitely believe that the immaturity of his reasoning process, which would be correlated with someone who's 15 is a factor in how this came about. I have had the opportunity to testify in Miller resentencing proceedings. Miller is a case before the Supreme Court, which relied on some of the scientific findings in Roper about why juvenile thought processes and decision-making is quite different from adults. Particularly at 15, which is considered a period of middle adolescence, there is a lot of structural change that is going on at that time of puberty, particularly in males as they are later developing than their female counterparts. The differences at that age include that your frontal lobes are not fully formed at that time. That's going to continue development. You can't stop development. It's going to continue until your mid-20s. But when you're only 15, that means that other parts of the brain have to stand in and basically take over the functions, stand in for that decision-making that will come online later in your 20s when you've got better judgment. What stands in is a highly emotional part of the brain, the limbic system. And that means that people that are 15 or middle adolescent period youths will tend to look at things in the world through an emotional lens and make decisions based on immediate rewards without the capacity to really reflect on the long-term decisions that they're making. They don't have the life experience, for one, and then secondarily, they have an inordinate response in their brain, as studied by MRI studies, to a dopamine rush, which affects their decision-making, particularly when they're stressed or in the presence of peers. So there are very specific differences of somebody that is this age in just how they would normally approach a problem or even consider how to get themselves through a temptation, for instance.
Based upon your involvement with him in reviewing the facts and listening to the different comments from his grandfather and Jaden, do you believe that in Jaden's mind that he was accepted by his peers?
Well, he mentioned that he didn't have a lot of friends. That was one thing that he said. I think that he had a place with peers during the period of time that he was a student athlete because he was decent at football and even played on school teams. So I think that that gives you a status with peers that you have a home, basically. He stopped playing football and he went to Okaloosa Academy, and he did not feel that he fit in at first there. He really was sort of isolated and eventually bonded with his co-defendant. But it's not my opinion that he's had a whole bunch of friends around the time of this offense.
In the whole process of him not playing football, was that anything related to COVID and things, the environment changes as far as, going to school, not going to school, being involved or not being involved?
Well, like many children in our county, they were redirected to doing virtual learning for a period of time. That's a poor match for someone that's got attention problems and he didn't do his work. And I think that affected his credits. I think that affected his grades, eligibility for sports and things like that. And it's, I think, a period of time until he regroups and goes back to public school in 9th and then was able to play sports again. So I do think COVID affected that, but also his attention limitations and low task persistence affected that too.
And then it's my understanding he ended up at the academy, the Okaloosa County School Board Academy School, is that right?
Yes.
Did he meet one of these people that was involved in this? Did he meet them through the academy?
That's correct.
Okay. Did you speak to him about his feelings about what had happened and what he put the victim in this case through?
Yes, I talked to him about both events.
And what did he share with you?
Well, he described the first event about taking Miss Flaherty's wallet as being related to leaving for an athletic event, and he didn't have any money. His granddad didn't have any money, and he didn't want to burden anybody, so he just spontaneously went looking and found a wallet and used that card. He described it as not having any common sense, about it being a dumb decision, and hindsight is 20/20, of course. I think at the time he was solving a problem in a bad way. The second event he described being driven to the mall, going into the store with the co-defendant. He is thinking that he can get marijuana there, thinking that even though he had maybe money for vapes, he didn't need to pay for marijuana, and taking it out in a box, going out to the car. After he left the scene, he's thinking about the victim and realizing that even though he's not going to do harm, the victim didn't know that. He's worried about the victim feeling scared, very scared. And it was important to me when I was interviewing him to figure out at what point did he start to realize that. And he said it was the exact same day that he realized that the victim would have been very scared by that.
And in your, on page 6, you get into summing it up. What do you believe would be the best outcome for Mr. Brooks? As far as what should the court do?
Well, it's important that the court has the opportunity to take into account, even though we're in adult court, this is a juvenile. And that is recognized by the Supreme Court to be a different class of offender. And that also means that his development is not done. He's going to continue to develop. And we already know that the risk of reoffending decreases with age. So naturally, he's going to be at less risk for reoffending as he gains this brain development. I think that it is important as he finishes development and his personality is still forming that he has access to pro-social and positive influences to finish this period of development. He would be, very, well cared for by his grandparents. If the court decided to do probation, they have since moved away from the area, so some of the negativity and the environment that he used to be in would not be a factor any longer. Certainly he has goals for his education, and he is still a juvenile, so he could finish his education. And I think that the opportunity to just consider those factors as the court makes the decision about it is important. We can do an individualized sentence because he is a juvenile and these factors are not the same as if you were an adult.
Okay. There's my question, John.
Your Honor, I just have a brief question for Dr. Harper. So, Dr. Harper, you, and I just want to be clear because I'm not sure I understand, you think that you're not making that diagnosis, but you think Mr. Brooks may have autism spectrum disorder.
We're all on the spectrum somewhere. That's why it's called a spectrum. There were 2 indications, in my opinion, that would suggest he's closer to the autism side of the spectrum based on also the family history of that being there. I did not diagnose him with autism.
Okay. But certainly can we agree that there are people with generalized anxiety or adjustment disorder and attention deficit hyperactivity disorder that don't do these kinds of things?
Yes.
There are people with this kind of family history that don't do these kinds of things, is that correct?
That's right.
Okay. Your Honor, that's the only questions I have for Doctor.
Anything else?
No further questions of this witness.
Thank you, Doctor. Is the doctor excused?
Yes, sir.
Thank you, ma'am.
Judge, I'm going to ask to briefly call his grandfather,
okay,
Mr. Brooks.
Madam Clerk, would you please swear the witness?
Do you swear affirm the testimony about to be the truth, the whole truth, and nothing but the truth?
And again, talk right into that mic because it's very directional. You got to talk right into it.
Just state your name for the record.
Alfred Brooks.
And Mr. Brooks, are you related to Jaden Brooks?
Yes.
How are you related to Jaden?
I'm his great-grandfather.
So Jaden's mother would have been your
Granddaughter.
daughter? Your granddaughter?
Yes.
Okay. And then you heard Dr. Harper say y'all have had him since he's about 3 months old?
Correct.
Okay. And I guess where I want to just kind of focus, when all this stuff happened, that time frame, what problems or what things were you witnessing that you were troubled by with Jaden?
Well, it started probably about 6 months or so before the incident. I noticed that he was changing. And at first I kind of chalked it up to him being adolescent, teenager, you know, whatever. So I just kind of watched him. But I saw that his, how can I put it, he was different. He wasn't the same young man that, you know, that was raised in a Christian home. He used to, at 3 years old, he used to say his prayers with me at night. And he was 10, he got baptized at church, and two of his cousins, which are my grandchildren also, he was 10 years old. They were afraid to get baptized, so he said, let's go over here and pray, and he prayed for them, you know, at 10 years old. So he was raised in a loving home. We tried to give him the life that he would have outside his mother, which is not a bad person, she just wasn't living good at the time.
Now, during this time that you were troubled, were there outside influences that
Oh, yes,
like
yes.
People, like, were there people coming to the house that you weren't aware were coming?
Exactly. What happened is I had a back gate on the house where we lived in Crestview. And the gate was always open every morning. I always closed it. Next morning I get up, it's open. I said, somebody's going out this house at night. So I put up a camera in front of the house. And I started seeing, you know, there would be like, one was a pretty new Ford pickup truck that I'm talking, you know, high-end, probably $60,000 to $80,000 that was picking him up, you know. And I saw someone in I think it was a Dodge Charger or something like that, was picking him up. But by the time when they got out of my camera sight, I could see the license plate, but I couldn't make it out because it was so far away, and I tried to blow it up, but the more I blew it up, it just got blurry. So, but I did see they were adult males.
So and that's where I was going. Were there some adult males?
Yeah, they were adult males, yes.
Okay. And did you contact law enforcement and say, hey, I think he's getting out there on the edge or something? Is there anything?
Well, we did at one time when he was acting up at the house. And, you know, I have a heart condition, and, you know, I can't wrestle with anybody. It didn't get to that point, but in case it did, so I was the one that called law enforcement. I didn't want to do it because that's my grandson. I love him. You know, he was raised in a loving home, and, you know, not to, you know, do anything like this.
So up to this time frame when this all happened, 6 months before.
Yes.
Prior to that, had you ever had any problems with
No. Model young man, you know, going to school, but, you know, I noticed that his grades was dropping. I talked to him about it, and he told me he was going to do better. So I left it at that, but, you know, because he had never lied to me before, you know. So.
Those are my questions, Your Honor.
Your Honor, I don't have any questions for this witness.
Thank you, Mr. Brooks. You may step down.
Thank you, Your Honor.
Judge, there are other people here in the courtroom for him. I'm not going to call them as witnesses, but I did want the court to know that there's a couple of football coaches and other family members that are here that if the court wanted to hear from, but I don't think it really matters. I don't think it's going to change the court's outcome. Mr. Brooks would like to just briefly tell you his feelings about one issue in this case.
Absolutely, yeah, he absolutely has the right to talk. It doesn't have to be briefly. It can be say what he needs to say. Come on up.
You want him to stand?
Yes, sir.
Okay.
Come on up here. Would you please swear the witness, Madam Clerk?
Please raise your right hand. Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Please be seated. Talk right into that mic.
You are Jaden Brooks.
Yes, sir.
What's your date of birth?
December the 5th, 2007.
Okay. So how old are you right now?
16.
How old were you when these events occurred?
15.
As far as the specific robbery goes, at the vape store at the mall, it's my understanding you want to tell the judge something about your feelings about how you feel about how that happened and how you feel about the victim in this case. And so I'm just going to let you tell the judge what's on your mind.
Well, it's just, I felt like during the events that was gonna happen and stuff, I felt like I had to. Felt like this what was cool. I was trying to fit in, trying to be like something I'm not, trying to be like somebody else, trying to portray an image that I'm not, or something like that. And once everything happened, it didn't even feel right. It didn't feel like me. And I don't know. It was just like it wasn't the right thing to do. I felt that after everything happened, and I just wanted to be around myself at that point.
Did you have any feelings toward, after it's over with and you're not there anymore, but you've left? Do you, in your mind, believe that you scared him?
Yes, sir.
Okay. And are you sorry for that?
Yes, sir. Truly sorry.
I think you said that you didn't, that you kind of, is my understanding you did this because you wanted to look cool in front of your friends?
Yes, sir.
Did you feel cool after it was over with?
No, sir.
Do you have any remorse for the fact of the way you made the guy feel?
Yes, sir. I hope he can forgive me for what I did. I hope he could, if he's listened to this or anything, I hope he will accept my apology.
And what is your plan now from this day going forward, as far as the judge is going to announce a sentence and nobody knows what it is? And
sir.
But do you want to go to school?
Yes, sir. I want to graduate.
Okay. Are there any school opportunities now at the county jail?
No, sir. There's nothing right now, but we're going to school, and they've been letting me cut hair in there.
Okay. So you'd like to maybe go to barber school and learn to cut hair?
Yes, sir. My coach right there, he was helping me when I was out. He said I could work in the barber shop, and that's what I really want to do.
If you get to where you're going, the system, I don't know, and again, I don't know what the sentence is going to be, but if there's available to go to high school and get your GED or to finish your high school education, do you want to do that?
Yes, sir.
Do you have any desire to play football again?
Yes, sir.
Have you ever thought about going to college?
I was thinking about going to JUCO. I was talking to my other coaches, talking about going to junior college and giving it a chance. And a recruiter was trying to talk to my grandpa while I was in here.
But the day that this happened, when you were out of the mall and you're going wherever, you said you didn't feel like yourself.
Yes, sir.
Okay. Those are my questions, Judge.
Your Honor, I don't have any questions for the defendant.
You may step down.
No further witnesses, Judge.
State, have any witnesses?
Yes, Your Honor. At this time, the state is going to call investigator Tia Firmingen to the stand. harm, it caused him financial harm. And in the 23 CF 1973 case, Ms. Flaherty's car was burglarized and her wallet was taken, and Mr. Brooks admitted to using her card. So he's also caused physical harm in the form of people's car being burglarized at their own house and financial harm by their credit cards being used. Your Honor, the state has to reiterate that this robbery case is one of the most serious crimes that someone could be charged with. That's why the legislature has categorized this as a first-degree felony punishable by life. The state does understand that Mr. Brooks was 15 at the time and now he's almost 17. The state does understand he's a teenager and does understand that he does not have a criminal history. That state believes that should be taken into account in the form of him not getting a life sentence. The state's not asking for life, but the state believes that the appropriate sentence is for him to be adjudicated guilty of all these offenses, for him to go to the Department of Corrections, not as a youthful offender, for him to go to the Department of Corrections with adult sanctions. Your Honor, he committed one, in the robbery case, he committed one of the most serious offenses that someone can be charged with. He pointed a firearm at another human being and he threatened their life. That is why the legislature has created the 1020 life enhancement. That's why he should get the 10-year minimum mandatory. And he should also get 15 years total in the Department of Corrections. Your Honor, he again committed a violent, unprovoked act. I know that he tells Mr. Harper that he felt remorse, but he sure didn't feel remorse when an hour after the offense he was trying to sell illegally gotten goods to other people. This unfortunately seems like a child who has done something that is an adult crime that he needs to do adult punishment for, that was raised in a home where he should know better. It seems like he has made a very serious choice that, again, is one of the most serious offenses that someone can be charged with. And the consequence has to be one of the most serious consequences that someone can get, which is a minimum mandatory offense, a minimum mandatory sentence. And the state does believe that the 10-year minimum mandatory should be imposed. The total should be 15 years. On the robbery, he should get 5 years on the burglary and the illegal use of a credit card in the 22 CF 1973 case, and credit for time served for the misdemeanor, and also get 5 years on the grand theft in 23 CF 1974. Your Honor, again, the state feels it needs to reiterate that this was a violent, unprovoked act on a small business owner. And again, the defendant deserves a Department of Corrections sentence. He does not deserve a youthful offender sentence. The court should not give him youthful offender sentencing.
May it please the court, Your Honor, if you give him the youthful offender, that's a variation of a prison sentence. I mean, it's still the Department of Corrections. They just have a different housing type thing, but it's still the Department of Corrections. Judge, at the same time the legislature passed this law saying this is a serious crime, they did not change the youthful offender statute and said because it's such a serious crime, then youthful offender classification is not allowed. And we know that they do things like that from time to time because it's what we all do for a living from different aspects of the cases. So the legislature, even though it was a serious crime, or it is, this was a serious crime, and even though it's an illegal crime, and they talked about it in the 1020 life, they did not take youthful offender classification off of the table. I had Dr. Harper testify as to his mental health issues, how he grew up, the problems that she recognized and saw, and I believe that he's had a fairly tough life, but his grandparents have been there, but he also got to the point to where he come across some people that he wasn't influenced and they were influencing him. He made bad choices, and as a result, we entered a plea today to the bad choices he made. We pled the other day, I guess we played months ago. But Judge, he does qualify for youthful offender, and that allows the court to give him 6 years in a youthful offender facility. And then, if the state is very concerned about how it all plays out, the court could give him 6 years youthful offender facility on the robbery charge, and then turn around and give him incarceration of some period of time on the breaking into the car charges, followed by probation. So there's a way to give a lot more supervision than the youthful offender that I'm looking for. I just don't think it's time to give up on him 100%, Judge. I think Dr. Harper said with educational help, with psychological counseling, and being involved, having things that keep people busy and basically help them grow, that he made a mistake and he was young. But I don't think giving up on him is the right answer either. So we're asking the court to impose the youthful offender classification, at least on the robbery charge, and then structure the rest of it whichever way the court believes is fair for this situation. That's all I've got, Your Honor.
Thank you. Okay. Court's going to take a brief recess, come back, and the court will make its ruling.
All right, please. Court's in recess. Just brief.
Yes, it is. I'm over to the restroom real quick.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in
Yeah, he told me I needed to get mine.
Please be seated. Would counsel approach?
Yes, sir.
In 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
So this is not my preference, but the court's going to reserve on this ruling, and the reason for that is it's very important. You know, there are certain decisions you have to make, but you have to make them based on the framework of the law, and the law being the statutory framework that the legislature gives us. There's a legal question regarding that statutory framework, so there's a legal question that I feel like I need to answer before I make the discretionary rulings that I have to make. So we're going to come back. We're not going to drag this out for months or even weeks. We're going to come back next Thursday at 1:30, and the court will make a ruling at that time. So I apologize. It was my intention to do that, but It was just a point that was raised that I feel has to be, determined. Can you all get some information to me by Tuesday, close of business?
Yes, sir.
Okay. Okay, it doesn't have to be anything, it can be just a letter, it doesn't have to be any form. But if you got any case law that speaks to it, include it.
I will look that up.
Okay, thank you very much.
Thank you, Judge.
All right, please.
Can I talk